We've got three speakers today from the team: Mark McKeating, partner James Howarth, and Lauren Ogden. They'll all be speaking to you, not necessarily in that order. The agenda is that Lauren will be talking to you with a case law update and also about potential changes in employment law that are anticipated following a change in government. James will be talking to you about the recent important case about holiday pay, and then Mark will be finishing off talking about employment tribunal trends. So without any further ado, I'm going to hand over to Lauren.
Morning, everybody. So I'm going to do the case law update to start with. So I'm going to be talking to you about the case of Tesco against Usdaw. So the facts of this case are that in 2007, Tesco undertook a reorganisation of its distribution centres, which involved some closures and some relocations. In order to avoid making redundancies, Tesco offered employees an incentive to relocate. This incentive was known as retained pay, which Tesco stated would remain as long as employees were employed in their current role, could not be negotiated away, and would increase each year in line with any pay rises. In January 2021, Tesco's proposed removing the retained pay and offered employees a lump sum equal to 18 months of the retained pay to encourage them to agree to the proposal. They advised that if employees did not agree to this, then they would consider dismissing and re-engaging the employees on new terms and conditions which would exclude their retained pay. Tesco's failed to obtain the employees' consent to remove the retained pay, and so Usdaw sought an injunction stopping Tesco from removing the benefit through fire and rehire. Usdaw was successful and the High Court granted the injunction. Tesco then appealed to the Court of Appeal, who set aside the injunction. The case turned on the wording of the contract and whether there was an express or implied term which prevented Tesco from firing and rehiring the employees. It was agreed by both the High Court and the Court of Appeal that there were no express terms of the contract which prevented Tesco from dismissing the employees in the usual way using the contractual notice provisions. Whilst the retained pay was a contractual term, this did not override the standard notice provisions which allowed Tesco to end the contract lawfully by giving notice. Where the courts disagreed was whether a term should be implied into the contracts, preventing Tesco's from dismissing and re-engaging the employees. One of the tests for whether an implied term is whether a term is implied or not is called an officious bystander test. This is where the implied term is so obvious that it goes without saying that it's part of the contract. The Court of Appeal considered this test and accepted that Tesco had sought to carry out the dismissal shortly after it introduced the retained pay scheme back in 2007, then the officious bystander test would have prevented Tesco from making the dismissal. However, in 2021, 14 years after the retained pay was introduced, the court held that an officious bystander would have considered that the contracts could be terminated on notice, and so there was no implied term preventing the dismissal. So what does this mean for employers? Well, the Court of Appeal in this decision have endorsed the fire and rehire as a legitimate way of making contractual changes and removing benefits which have become unsustainable with the passage of time. Employers will welcome this decision with the prediction that a recession looming and employees arguing for pay reviews due to the cost of living crisis. The fire and rehire approach should still be approached with caution, and employers should take advice before making any decisions on using this method. One significant risk is unfair dismissal claims in respect of employees who have more than 2 years service. The recent P&O ferries dismissals faced a lot of criticism and has led to the government announcing a new statutory code of practice on the use of fire and rehire. This code is likely to require employers to hold fair, transparent and meaningful consultations on the proposed changes to the employment terms. Employment tribunals will be required to take this new code into account and could even increase an employee's compensation by 25% if the employer has not followed the code. We're still awaiting details on this code. However, employers should ensure that contracts of employment are drafted with clear and unambiguous language, which could be interpreted as guaranteeing contractual entitlements on a permanent basis. Usdaw have made it clear that they intend to seek permission to appeal to the Supreme Court, and so will be monitoring any further decisions in this case. Moving on, I'm going to talk to you about what impacts the new Prime Minister might have on employment law. So during the Conservative leadership contest to become the new Prime Minister, Liz Truss made several pledges which could impact both employers and employees if they are implemented. I'm going to discuss some of these key commitments and what the impacts of those changes could be. So first of all, Liz Truss stated that she's committed to reviewing all retained EU law on the basis of whether it supports UK growth or boosts investment, and replacing those that do not with UK law. She's pledged that any EU laws which are not replaced within 15 months will disappear under a sunset clause. This just means that they will automatically end without Parliament needing to officially remove the legislation. Several employment laws could be affected by this proposal, including the working time regulations and TUPE. Liz Truss has voiced her intention to reform the working time regulations by removing the limit on the 48-hour working week. Employers often have employees opting out of this limit in the contracts of employment and working in excess of 48 hours where it suits both parties to do so. And so this is not expected to be a dramatic change. However, employers will still have health and safety obligations to ensure employees do not work excessively, and will not be able to increase contractual working hours without consultation with the employees, or they could face claims for constructive dismissal. We may also see the amendments to the working time regulations in respect of calculating holiday pay. This is an area which has become complicated by changes in case law, and my colleague James will be discussing this with you shortly. And so reform which clarifies matters may be welcomed by employers. In respect of TUPE, this is unlikely to be repealed in its entirety, but there have been suggestions that the new Prime Minister will look to amend the ability for employers to make changes to employees' terms and conditions after a transfer, as this is currently difficult under the legislation. Liz Truss has also committed to immediately reversing the rise in national insurance contributions, which was introduced during the pandemic, and confirmed that she will order a review of the off-payroll working rules. So changes to the IR35 regime were made in April 2021 to include private sector and prevent avoidance of tax and national insurance contributions by using an intermediary between a client and a worker. Liz Truss has criticised these new rules for wrongly taxing the genuinely self-employed, but no announcement has been made yet as to what these changes could entail. During her leadership campaign, Liz Truss also pledged to remove diversity advisors from the government departments and scrap diversity training. Liz Truss has claimed that this will save the government £12 million per year. Whilst this is not a direct change to employment law, it is a useful reminder to employers of the importance of equality and diversity training in the workplace and the risks the government may face by removing these roles and training. So sufficient training on equality, diversity and inclusion in the workplace will put managers and employees in a better position to deal with issues and make good decisions, reducing claims of discrimination. If an employer does face a claim for discrimination, it can be offence to these claims if they can demonstrate that they took reasonable steps to prevent the act of discrimination. Unless they have anti-discrimination policies in place or provide adequate training to employees, this defence is unlikely to succeed. With the ongoing national rail and postal strikes in the UK, Liz Truss has also said that she will propose legislation that makes it more difficult for industrial action to take place. These changes could include introduction of minimum service levels during strikes for critical national infrastructure, raising the ballot thresholds in support of a strike from 40% to 50%, so more members would need to vote in favour of a strike action for it to take place. Increasing the minimum notice period for strike action from 2 weeks to 4 weeks to allow businesses to better prepare for the strikes, and introducing a cooling off period after each strike so that unions are unable to strike as many times as they want in the 6-month period after the ballot. So whilst these proposals are not set in stone, and we've yet to see specific details on how these may be implemented, it is certainly something which we'll be keeping an eye on and could significantly change employment law. So I'm going to hand you over to my colleague James and we'll discuss changes in holiday pay.
Thanks, Lauren. So I'm going to talk to you today. Well, we're going to spend a little bit of time on a case that reached the Supreme Court. So this is the case of Harper Trust versus Brazel. And as Lauren and Kevin had mentioned, it concerns the payment of holiday pay. So it's quite a big decision, really, because it could have quite far-reaching consequences for some employers, certainly those who engage staff on 0-hour, term time and part-time work. So first, we're going to have a think about some of the key facts of the case. So Mrs. Brazel was a music teacher. She was based at the Bedford Girls' School, which was operated by the Harper Trust. Her contract required her to work during school terms only, with her weekly hours varying dependent on the needs of her lessons. So essentially, she was a part-year worker. So she remained employed from year to year, but she was only contractually required to work at certain periods during those years. i.e. during term time. She was only paid for the hours that she taught, and she was required to use her annual leave during school holidays. So from September 2011, the Harper Trust decided to change the way that they were calculating Mrs. Brazel's holiday pay. And they did this by following what was then ACAS guidance. So that change in approach essentially meant that she was going to receive a lower amount in terms of holiday pay. And as you can probably imagine, Mrs. Brazel was not particularly happy with that approach. So what she did is she brought an unlawful deduction of wages claim before an employment tribunal. So there's various differing decisions were reached at the employment tribunal, the appeal tribunal, the Court of Appeal, and finally we've had a final decision at the Supreme Court. So let's have a quick look at the law. So the relevant legislation / regulations here is the Working Time Regulation. So this implements the EU Working Time Directive, and that regulation states that a full-time employee or worker is entitled to 5.6 weeks paid holiday. So the amount of that payment depends on the average weekly pay, but the amount of holiday should not change. Average weekly pay is set out in section 221 to 224 of the Employment Rights Act, and that states that those working atypical hours, well, their pay is calculated over the average earnings of the preceding 52 weeks. Although, to be fair, it was the preceding 12 weeks when Mrs. Brazel first brought this case. So there were two different approaches. The first approach, which I'm going to call the percentage method or the pro rata principle, well, this was the Harper Trust approach. So they argued that the statutory entitlement of 5.6 weeks holiday pay should be prorated where an employee has worked fewer weeks than a full year. So that ACAS guidance I mentioned before, so that guidance said at the time that the amount of paid holiday due could be calculated by multiplying the earnings of a worker by 12.07%, hence the kind of percentage method. So that 12.07%, that's the proportion that 5.6 weeks bears compared to a working year. That's how you get to that 12%. So the Harper Trust, they made payments for Mrs. Brazel's leave at the end of each school term. And they did that by applying that 12.7% to her previous earnings in the previous term. So what the trust said at the Supreme Court, they said and argued that there had to be some sort of principle of prorating, because they had to prorate it, the holiday entitlement, to reflect the hours actually worked. Otherwise, you'd get some absurd decisions where people could work a few days a year but actually turn out having a larger percentage of holiday entitlement than somebody who works full-time hours. They also tried to rely upon the EU Working Time Directive, because that directive did allow member states to prorate holiday entitlement to reflect the number of weeks somebody actually worked. So that was their argument, that was their position. The second approach is the 5.6 week approach. And this is essentially Mrs. Brazel's approach, because she disagreed with the percentage method. So what she said is that she was entitled to the payment of 5.6 weeks holiday in accordance with all legislation for workers with no normal hours of work. He said that she was under contract during the whole year, therefore she should receive holiday pay for the for each of the weeks in the year, not just the weeks that she worked. And finally, her argument was that it should be based, her holiday pay should be based on her average pay during working weeks, and that the 12.07% method had absolutely no basis in law. Let's have a quick look at the Supreme Court decision. So the Supreme Court entirely rejected the percentage method calculation, so essentially the Harper Trust approach. So they accepted that the EU Working Time Directive allowed members to legislate to allow pro rata, but in England and Wales, there is no domestic law that specifically does this. They were pretty clear. The working time regulations state that all workers have a fixed and universal right to 5.6 weeks holiday, and employers can only adjust this where someone's employment either starts or ends partway through a leave year. So the Supreme Court addressed the Harper Trust view that it would lead to some absurd decisions. So what they said is that actually for atypical workers, they're only really slightly favoured in this decision in the main. There will be some odd results that in certain cases, certain very specific bespoke cases, that might lead to the situation that Harper Trust kind of explained, but that doesn't justify a fundamental rereading of the statute. Excuse me. So as Lauren mentioned before, I would not be surprised if we do get future legislation that kind of addresses this, because it does seem slightly unusual. However, as the law is as it is, and currently there is no legislation that stops you from essentially favouring part-time workers in these situations. So yeah, the last thing to mention is that the Harper Trust did say, well, one of their arguments was that they were just following ACAS guidance at the time. Unfortunately, the Supreme Court gave this very short shrift, which I suppose is a cautionary tale for all of us moving forward. And they explained that ACAS guidance can never affect the proper construction of statutory wording. So let's have a look at the current position then. So where essentially are we? So atypical workers under a permanent contract are entitled to 5.6 weeks holiday pay per year, regardless of the amount of work they actually do. Pay must be calculated in accordance with the legal provisions for holiday pay and not the 12.07% method. So in practice, this does not impact part-time workers with set hours. So for example, you have a part-time worker, you have an employee who works 3 days a week and does that working pattern doesn't change and does that for the full year. Well, in those circumstances, you can calculate holiday entitlement as a reduction compared to a 5-day week. So who does this affect? So this decision only affects workers who work for part of the year under a permanent contract and have done so for more than a year. So those are kind of the three key factors. The reason for more than a year is because holidays do accrue at 1/12 of their annual entitlement in the first year. So these are individuals who do not work the full number of hours worked by full-time workers or the full number of weeks worked by part-time workers. So it is relatively complicated. But what it does mean is it'll only impact a certain type of worker. And as I mentioned before, that will likely be seasonal workers, those working in term time, and 0-hour workers as well. So although the effect might be relatively limited for some employers, well, there'll be lots of employers that use those types of workers will be very, very significantly affected. And certainly in sectors like health with the NHS, education with schools and colleges, that needs to be reconsidered if you have any of those individuals. And the final kind of takeaway from the Supreme Court decision was that this doesn't affect contractual holiday. So when I say contractual holiday, I mean holiday above and beyond the statutory entitlement, so above and beyond 5.6 weeks. So any contractual holiday, additional holiday, that can still be paid pro rata to reflect actual hours worked. So let's have a quick look at the implications there. So what I'd say about this is it's a very public case. Unison backed Mrs. Brazel throughout the process. They're actively supporting workers in general now just to challenge holiday pay. So I think there's every chance we'll see a lot more of these types of claims in the future. That being said, there are quite a few limitations as well that you can apply, which are really useful for employers. So firstly, a break of more than 3 months between two underpayments will prevent a worker from claiming any deductions from before that 3-month gap. And we can say that from the Bear Scotland case. So for example, let's just say you underpaid an employee for 2 months, but 3 months before that, 3 consecutive months, you correctly paid them. Well, that 3 month would be a gap for any previous underpayments. The second limitation that's useful is that employees are prevented from claiming for more than 2 years worth of underpayments under the Deduction from Wages Regulations 2014. So there's a kind of final cap in the tribunal of 2 years worth of claims. What I'd say about those two limits, though, is there's been quite a lot of strong views from the judiciary in subsequent cases that actually that position might be wrong. So at present, it's correct and case law supports that, but I wouldn't be that surprised if in the future the 3-month, 2-year limit ends up falling away. And the final thing to mention, in some very limited circumstances, and depending exactly on what's written in an employee's employment contract, or potentially they may be able to bring a breach of contract claim in the civil courts that potentially could go back 6 years. Excuse me. So the final slide, we're just going to talk about some kind of practical steps and things that you can do now. So the first thing I would very much recommend is you undertake a review of all contracts of any casual staff that you engage and identify those employed on a continuous or permanent basis that might have been underpaid. The reason for this is, firstly, that you'll allow you to understand the potential risk moving forward. But secondly, it'll also let you consider whether that type of arrangement really works anymore. I mean, any individual under those kind of engagements will have essentially long periods of time where they're not working. So it might be sensible to consider whether you should end that kind of arrangement and move towards something that's more temporary, maybe that ends on a weekly or monthly basis, or certainly ends at the end of an assignment. And in that way, you'll kind of mitigate any of the risk associated with this holiday pay. So speaking of mitigation, so once you've identified the risk with some of these engagements, well, it's probably sensible to think about mitigating it. And in how I do that is I'd apply some of the technical arguments we've talked about, so the 3-month, 2-year limits, and whether that, in a way, kind of undermines some of the claims that people might bring. Once you've done that, well, you'll be in a good position to understand the liability, the quantum of your liability, and you can start to allocate some funds now if you ever have to pay that back. And also, it might be sensible to speak to your insurer to see if actually, once you've quantified that liability, whether they'll compensate you for any of the risks associated with it. And the final thing to think about is tactics. So considering your approach once you've done the review and the mitigation, are you going to compensate all staff who've been underpaid? Are you going to try and resolve it now in terms of future payments and hope that nobody notices? Or are you going to wait and see on if an employee raises it as an issue and offer settlement on a case-by-case basis? So I think that entirely depends in terms of the cost you've identified in the first kind of stage I mentioned before, because then you can certainly identify the risk and work out the kind of value of it in terms of the sums that you can allocate. And then that will very much guide what you do in terms of your next steps. I will say, though, that there's certainly a reputational management element to taking an approach where you kind of settle it on a case-by-case basis. And sometimes it might be better to get ahead of these things. But anyway, as you can probably see from the last 10-15 minutes I've been speaking, that it's a really complex area of law. And if you are exposed, well, your next steps need to be considered really carefully. So if you do that review, you do that mitigation exercise, and you do find you've got some liability, well, as you can probably imagine, I'm going to recommend that you contact us. We can discuss it in a bit more detail, and then we can advise you on some bespoke and really focused next steps, really, to kind of get you through what potentially could be a pretty expensive issue. So I hope you found that useful. I'm now going to pass you over to Mark, and I think he's going to talk to you about the HR hotspot.
Good morning, everyone. So I'm going to be delivering the HR hotspot today. And it goes back to a conversation I had with an HR manager a few months ago, where she told me the 2 worst things she could find in her in-tray were, number 1, a data subject access request from an employee, and number 2, an employment tribunal claim, largely because they're expensive, they're time consuming, and get it wrong, and my goodness, does it reflect badly on your organization. So I'm going to be looking today at the process, some drill down on some key points on that, some of the trends that are being reported from the tribunal and also that we're seeing in practice, and finishing with some comments around how you can potentially avoid, certainly reduce the risk of tribunal claims from happening in the future. So in terms of the process will start with the claimant contacting ACAS through the early claims conciliation process. This process can take up to 6 weeks. I should say that it's not obligatory for the claimant to engage in this process beyond reporting the facts of their dispute to an ACAS conciliator. So they can simply say, I don't want you to conciliate, I just want you to give me my reference number and I will go to the tribunal. So actually, an employer may never find out that a claimant has actually gone through this process until they receive the ET1, the claim form. But in most circumstances, I think a claimant will want to conciliate, will want to perhaps get a sense of whether the employer is interested in settlement and forgo the need of an employment tribunal. So if the parties wish to conciliate, there's an early conciliation period, mentioned up to 6 weeks, where parties reach settlement. They can enter into a COT3 agreement, which is like a short form settlement agreement. If conciliation fails, then the claimant will proceed to bring a claim. The other benefit of ACAS conciliation process is it can extend limitation by up to a month. So in an unfair dismissal case, which is normally 3 months, the claimant would have to bring a claim from the effective date of termination. That will add another month on. And likewise in a discrimination case, where it will be 3 months from the last act of the series of discrimination acts, or the last discriminatory act, then it would extend that by another month. So if the ACAS conciliation process doesn't work, the claimant may pursue a claim to an employment tribunal. And I'm sorry to report, there's little disincentive for a claimant not to bring a claim. There are no fees. Fees were abolished in July 2017. So a lot of claimants may take the view, I've got nothing to lose here. And as we'll come on to talk about, the cost position is slightly weak when it comes to employment tribunals. So in some ways, there's nothing to lose in pursuing a claim. Obviously, for the employer facing a claim, it tends to mean money, it tends to mean investment and management time. So the claim will start with the ET1. I should say that there is a delay in the employment tribunal system in terms of administering ET1s. So years gone by, as an HR manager, you might have thought, well, limitation has now expired. Actually, what we're finding now is a few weeks later, the tribunal are sending out the ET1s. So there is this delay, unfortunately. The claim's obviously still in time. The other worrying trend, I guess, is that some claimants are putting the wrong address on the ET1, which means the ET1 may go to a different address. So if your business has a number of different offices, then you may find it goes to the wrong address, which can, again, cause some delay in terms of the ET1 coming back to this central place, which is perhaps the HR department. And that can mean, worryingly, that you miss a deadline for submitting an ET1, submitting an ET3. An ET3, or the response form, needs to be submitted within 28 days from receipt of the ET1 form. So it's always important to check the ET1 when you receive it from a tribunal, just to ensure that you've got sufficient time in which to prepare your response and to lodge it accordingly. So just a few points on disclosure. The tribunal's approach is that the parties place all cards on the table. So if there's any evidence which is relevant to the issues in the proceedings, you're obliged to disclose them. And equally, there's an additional obligation on a legal representative not to mislead a tribunal or a court, in which case all documents need to be disclosed with your opponent. Those documents are those that you tend to rely on. Documents may adversely affect your own case, adversely affect another party's case, or even support another party's case. So you do have to disclose documents. And by documents, I mean it could be emails, it could even be recordings, It could be anything that is written down. And when you go through managing a grievance or a disciplinary, you need to really ask yourself when you record evidence as to whether you want this disclosed in a tribunal, because it does become admissible. So those emails from a CEO or a manager saying, I want rid of this idiot, unfortunately could come back to bite you because they would be disclosable in tribunal. The other trend we are seeing with disclosure is that claimants are seeking early disclosure, in some cases before an employment tribunal claim is issued, by way of a data subject access request. Some respect it's a fishing exercise to find out what evidence is in place. Savvy claimants are waiting until the evidence has been created in which to request documents. So this particularly comes into play if a business has engaged maybe an HR consultant or an employment law consultant to manage the process. Any evidence that they create, which could be in the form of an advice note or any correspondence with an HR manager, would be disclosable because those parties will not have the benefit of legal professional privilege. Some employment law consultants may say, well, actually, we've got the benefit of litigation privilege, but that is questionable, particularly where the evidence has been created so far in advance of litigation actually taking place. So that is something to bear in mind, something to bear in mind for HR and employment law consultants as well, as to whether you want to be embarrassed by having to send your file to a tribunal judge to consider or to send it to the other side. It may mean actually that what you thought was a very good case is significantly undermined, and ultimately it may mean it drives up the price for settlement. Obviously, if you instruct qualified lawyers at the outset, any email from a CEO to me, for example, that says, I want rid of this idiot, would be privileged and would not be disclosable. So certainly an advantage in engaging legal support early doors. A couple of things to say on witness statements. So again, witness statements in my experience can be incredibly persuasive before an employment judge. I think they affect prospects by about 10%. So a good case can be significantly undermined by a badly performing witness. Years gone by, a witness had to read a statement aloud in a tribunal hearing, whereas that's changed, and now there's very much emphasis on statements taken as read, which again places a lot of emphasis on the preparation of that statement. Statement is useful insofar as it will help to fill any gaps in the documentary evidence. It will help explain documents in a bundle. It will help to explain a decision that has been taken and to resolve any issues in dispute. Again, recommend you take legal advice when preparing that statement. And again, it's a good opportunity. I know when I speak to witnesses, it's a good opportunity to really stress test how they're going to perform at a tribunal hearing. And actually, if we're a little anxious about a witness who may break under some pressure, then you might want to think about, well, how that will affect the overall prospects of you defending a claim. And again, that may be something that points you towards settlement. So it can be a really good exercise to do in the early stages, just to test your evidence. In terms of the hearing, what we're finding is once, in terms of unfair dismissal claims, the tribunal's mandate is to list a hearing for an unfair dismissal claim within 6 months from receipt of the ET1. Slightly different in how they manage discrimination claims or whistleblowing claims. It tend to be that they will list a preliminary hearing to determine the issues. And this can be particularly useful if you're dealing with a litigant in person who's maybe not used to the tribunal process. And recent experience I've had, the judges have been incredibly helpful in actually taking the claimants through the process, getting them to drill down as to what their claim is, And in some cases, we've had some success with the judge encouraging a claimant to withdraw during that early preliminary hearing. Largely, they're used to understand the issues in the case and to set up case management orders in terms of preparing for the full hearing. So we don't tend to get tribunals that will list hearings for discrimination claims. It tends to be there will be a preliminary hearing first, and at that hearing, the full hearing will be listed. In terms of lead-in times at the moment, I had a 3-day case that was listed a few weeks ago in Manchester, and it's been listed, discrimination claim, in front of the full panel. It's been listed towards the back end of 2023. The judge did tell me that 5-day cases are now going into 2024. So unfortunately, there is a bit of a delay to these cases, which again puts a lot of emphasis on, I think, speaking to witnesses early on. Otherwise, there's the passage of time, there's always a risk that they could forget things. And again, I think that's likely to undermine your case. Just want to say a couple of things in relation to costs. I get asked this question quite a lot by HR managers. Well, surely if we win, we must be able to claim our costs back. It's a bit unfair that we have to incur costs when it's not our fault that we're here in the first place. Well, that's not strictly true for the tribunal process. It's the position in relation to other courts, such as the High Court, where the loser will pay. A general rule is the loser will pay the winner's costs. However, it works slightly different in the employment tribunal system. Costs will be borne by each party. There are circumstances in which the tribunal must order costs. They're very limited to exceptional circumstances, such as where there's consideration of the tribunal making an order for reinstatement or re-engagement, and the respondent employer fails to produce the relevant evidence, and that may lead to a postponement or an adjournment of the hearing. Claimant may seek costs in those circumstances. However, there's also some discretion for the tribunal to award it where a party has behaved unreasonably in the process, or in pursuing their claim that it's been unreasonable behaviour, or they've been vexatious or acted disruptively in the proceedings. So examples of that would be where a claimant fails to comply with a case management order. So perhaps they fail to exchange documents or a witness statement, and that has a knock-on effect of potentially putting a hearing in jeopardy, and there's a delay caused by that. So that may be a case in which we would direct a tribunal to make a costs order. Also, where a claimant pursues a claim which has no reasonable prospects of success, and this is where, in terms of tactics, making a cost warning can be very helpful and can protect your position on costs later in proceedings, particularly where you set out a clear analysis of the claimant's claim, which is weak, and you give the claimant an opportunity to take some advice and reflect on whether it's a claim they wish to pursue. Otherwise, if they fail to withdraw, you'll ask the tribunal to make a cost order. So that can be a very effective tool when dealing with claims which have no reasonable prospects of success. Some other options you have: a party can seek a strikeout of a claim if there are no reasonable prospects of success. Tribunals are very reluctant to make these orders, certainly without hearing evidence. So you probably find a tribunal judge will be reluctant to make an order giving the onerous impact on one party. Deposit orders are more popular with tribunal judges. They can be, again, a very effective way to engineer an early withdrawal of a claim. So a deposit order would be made if a tribunal judge feels that a claim has little prospects of success, and deposit orders can be discussed as early as the preliminary hearing. So I had one a few months ago where a tribunal judge made a deposit order because it felt as if there was a discrimination claim, just had no legs whatsoever. The claimant couldn't explain what protected characteristic came into play and made an order. In terms of the order itself, the claimant had to make a payment into tribunal in order to continue with their claim. The tribunal judge questioned the claimant on his financial means in which to make payment. He said he had lost his job because he was discriminated against and was unemployed, receipt of income support, and therefore simply couldn't afford significant monies. He also had 10 heads of claim. A tribunal judge considered it appropriate that he pays £50 per head of claim. So if he wanted to pursue all 10 heads of claim, he would have to make a payment of £500 into tribunal, and that had to be paid within 14 days. Needless to say, he didn't make payment and his claim was struck out. So again, in terms of a trend, in our experience in the team, we're finding that tribunal judges are warmer to making deposit orders as opposed to a complete strikeout of the claim. So let's have a look at the possible compensatory awards that could be made by a tribunal. There is a cap on unfair dismissal claims. It is a cap which is increased every year, normally on around the 6th of April. The current cap is the lesser of £93,878 or 12 months' salary. The cap is removed if the unfair dismissal relates to whistleblowing or there's an element of discrimination. So what we're finding is claimants that are perhaps able to secure alternative employment straight away and their compensatory loss, so their loss of earnings is only a few months. What they're doing is tagging on a discrimination claim on the basis of just increasing that potential compensation pot. So in terms of other orders, reinstatement and re-engagement are possible. It's down to the claimant to tick the relevant box in 81 that they would consider that. So reinstatement would be the claimant asking for their job back. Re-engagement would be a job with the same employer but in a different capacity. These are very rare orders. They are tribunals will make them in about 1% of successful unfair dismissal claims. There is a penalty for an employer that fails to comply with an order of reinstatement or re-engagement, and that would allow the tribunal to award the claimant a further 26 to 52 weeks pay, which is capped at the statutory cap of £571 per week. So effectively it means a potential further compensation of up to £30,000 if an employer fails to reinstate or re-engage the claimant. I want to talk about injury to feelings next. Injury to feelings relates obviously to discrimination claims. The tribunals will still go to the tried and trusted Vento formula, which emerged from a case a few years ago. Again, Vento guidelines are updated every year to take into account the inflation. So I suspect next April when they're reviewed, they will be quite significant in terms of how they have increased. As it stands at the moment, there are 3 bands of seriousness. The lower band, the entry point is £990. That goes up to 9,900. The middle band will start from 9,900 and goes up to 27,400. And the upper band starts from 29,600 and will go up to 49,300. In exceptional cases, a tribunal can award in excess of 49,300. So that's where the big money is, which may explain why we are seeing this trend that claimants are tagging on to their unfair dismissal claims, discrimination claims, because potentially the odds are quite high. Potentially the ante is upped insofar as employers are concerned. So what I've done as part of this, I wanted to find out what average awards have been made by a tribunal. Now, unfortunately, we don't have up-to-date statistics on this. So the latest statistics are from the 1st of April 2019 to the 31st of March 2020. So just before, I guess, COVID kicked in. The average award for an unfair dismissal claim at that time was £10,812. A race discrimination claim was just shy of £10,000. Sex discrimination claim was around £17,000. A disability discrimination claim was £27,000. Age discrimination was like £39,000. And sexual orientation was just shy of £28,000. For anyone interested in, because I've not put the figures on the slide, anyone interested, if you want to send me an email, if you'd like a fact sheet that we have prepared in the team, and we can send that over to you, which has all these figures, which again is quite a useful guide to look at, particularly when you're weighing up whether you want to defend a tribunal claim or whether it's cost effective to reach settlement. So with those statistics in mind, bear in mind March 2020, they're likely to be higher 2 years later. So it can be a very costly process if you're on the receiving end of a successful discrimination claim. The tribunal also has discretion to make recommendations. And again, in an ET1 form, you may see a box ticked by a claimant to say, I would like the tribunal to make some recommendations. They may not understand what that means, but it's likely to encourage the tribunal, whether it's a positive finding of discrimination, to make some recommendations that the employer carries out some training or retraining in some cases, updates an equal opportunities policy. And in one case, we came across a tribunal had actually ordered a large employer to set up a review panel to oversee their equal opportunities policies and to make decisions affecting the business going forward. So again, that's something which, bear in mind, tribunal decisions are published. Getting a recommendation can be quite damaging for an organization. So again, these are just some things to consider. And it may also encourage you to put steps in place before you get to a tribunal hearing. So I'm just going to come on to talk about some trends that we're seeing. So during COVID, the tribunal held remote hearings, and that was largely to deal with a bottleneck around growing claims that just weren't being heard within the mandated time. This has been the case for unfair dismissal claims. So more straightforward claims, the tribunal will use what's called a cloud video platform in which to hear those claims. So last week it was announced that the tribunal are going to stick with that, which I think is really positive because it saves a lot of time. It saves witnesses waiting around to give evidence, and probably means that claims can be dealt with in a swifter and more efficient manner. Discrimination hearings will probably, tribunals will adopt a different approach when it comes to hearing discrimination claims. The default position is that they are to be heard in person. Now and again, the tribunal may move from that, but I think where a tribunal has a panel considering claims, then it's likely that they will be heard in person. And again, that may explain why there's been such a delay in listing claims in relation to discrimination complaints, because it's finding an employment judge and two panel members to sit, and that's why bear in mind tribunals are under-resourced and still actively recruiting employment judges. That probably explains why hearings are going into the back end of 2023 and 2024. We're also seeing an increase in what we call revenge cases. We've had a few of these in the team. And these are cases where claimants are not driven financially. So they're not motivated by securing a windfall when it comes to settlement. What they want is almost to put two fingers up to their employer or their manager by putting employers to the rigor of having to defend the claim. So they're not interested in any form of settlement. In fact, their pot of compensation may be significantly lower than what their legal fees will be, but they're held bound on airing their grievances in a public court and essentially getting one over on a manager. So these can be very difficult to manage, particularly where, let's say, the individual's not being driven by any financial incentive, and they're, in these cases as well, they're probably more likely to make data subject access requests and just throw as much mud as possible at the employer. We forecast a potential increase in claims during the economic crisis. I guess as we embark on a potential recession, employers may be tempted to make cuts, particularly having recruited staff on high salaries following the Great Resignation. They may be inclined now to make redundancies or even manage employees out of business on performance grounds, particularly if the employee is less than 2 years service. We have also seen a rise in claims relating to topical issues. So menopause, which is it's been in the news the last couple of years. There's been the campaign from Delina McCall. Menopause claims have quadrupled in the last few years. We've seen an increase in neurodivergent claims. So claimants may have autism or ADHD, which may qualify them as a disabled person or bring a disability discrimination claims on the back of that. And we're seeing over the last 12 months, we've seen a third increase in those types of claims. Health and safety related claims as well have gone sky high. There's been an increase of 114%, which has been about 15,000 claims in the last quarter, largely as a byproduct of COVID, where employees are nervous about returning to work on COVID grounds and have been punished or dismissed as a result. Then they may pursue a claim for health and safety related dismissal, which again is not subject to the cap. So again, can be big money involved in terms of settlement or even a compensation award. So we expect to see these claims continue. I think as we all still struggle with returning to work and working in a hybrid fashion, I think these claims are not going to go away overnight. And we expect to see more tribunal decisions over the coming weeks in relation to these claims. Just having a look at your approach to employment tribunal claims. It's always good when, certainly I find it useful when speaking to clients early doors when you carry out a risk-benefit analysis of the claim as to actually what your approach is to defending tribunal claims. Some clients will take the view, well, actually, we're going to defend claims all the way because we've invested a lot of time in our policies, training our staff, and we want to send a strong message to the workforce. So I guess it's a bit more long-term thinking. And some clients will say to me, I'd rather pay your money, pay your fees than pay the claimant. And even for a claim that's only worth a couple of thousand, they're prepared to pay legal costs, which could triple that if it meant going to tribunal and getting a positive finding. Look, I guess you take a view based on your prospects of success, but one thing you need to be careful about is potentially opening the floodgate of claims. Tribunal claims or tribunal judgments are now published on a public portal. And we came across a household name a few months ago when we were looking at some of the decisions, and it became clear that they had a run of claims that they disposed of before a hearing. So they had no full judgments. So a lot of the cases were withdrawn before a hearing, which, okay, you might say, well, perhaps the claimant withdrew because they were put on a cost warning or they became anxious and just didn't fancy going to a full hearing. But I suspect a lot of those claims were settled. And this business, no doubt, has a as an approach whereby they will probably settle everything and just avoid going into court because maybe publicity, or actually, you know, they're concerned about the amount of management time that is wasted as a result of tribunal claims. Commercial factors will come into play as well. I mentioned the COT3 agreement before. That can be a useful way to settle a claim. We're seeing an increase in employers also considering settlement agreements, particularly where there's some commercial issues, and you may want to ensure that there's more scope around the claimant agreeing to a confidentiality provision within limits. I mentioned earlier about sending out a message. I think equally supporting your managers is a worthwhile consideration. The last thing you want to do is to a manager to make a decision and for you to say later on down the track, well, I'm not sure you've made the right decision, and as a result of that, we're now going to have to settle the claim. So that can sometimes send out the wrong message. So I'm going to finish with how to avoid or mitigate the risk of tribunal claims. Unfortunately, for those that have tuned in thinking I'm going to say there's a silver bullet for avoiding tribunal claims, that's not the case. As we mentioned before, we were seeing a rise in revenge cases. So it's very difficult to completely eliminate the prospects. Having said that, you can take steps to improve your position. And it's basic things like having a legally compliant contract. So a contract which captures the latest changes we've had in April 2020. So making sure your contract refers to training requirements, leave entitlements, and provides a full list of contractual benefits. Other things as well, making sure the contract is clear when it comes to payment of bonuses, even leave entitlement. We've had some calls about Monday in terms of whether it is a public holiday than one that employers should be giving to their staff. James also mentioned holiday pay as well, just being very clear in terms of how your position is outlined in relation to those points. Also having robust workplace policies. So do you update your staff handbook? Do your managers follow procedures? Do they do it in a consistent manner? Training, something that Lauren mentioned in terms of training, which is it does form part of the statutory defence for preventing a claim of harassment in the workplace if you can demonstrate that you have trained an individual, a perpetrator, and they've acted off their own accord. So training can be a worthwhile investment, particularly where you're going to empower managers to make decisions. Make sure managers are aware of equality, diversity, and inclusion issues, and they ultimately make the right decision. We find a lot of claims emerge from a breakdown in trust between an employee and a manager, particularly if an employee feels that a manager is out to get them. And in most cases, I think managers are just not trained to deal with personnel issues, and that is clearly a risk for businesses. Other things, just making sure you handle disciplinary and grievances correctly. Consistency. Do you keep a log of your decisions to ensure that everyone is treated fairly? Do you follow procedures to the letter? Risk areas, we're seeing a lot of claims emerging from performance management. I think part of the reason for that is if you provisionally select somebody at risk of redundancy, I think employees maybe feel that's less personal than being told by their manager that they're not performing well in their job. So these are very emotive issues for an employee, and you may find they're more likely to bring a claim on the back of any performance management process, particularly if that process hasn't been handled fairly and hasn't been taken in a consistent manner. Also, where we find some weak areas for managers, particularly in dealing with sickness related issues, is it a case you need to refer to occupational health? Do you completely exclude the possibility that the claimant may have may qualify as a disabled person, in which case we may have to make some reasonable adjustments in the process. So these are all claims that we're starting to see, and I think that goes back to a training issue with managers. So again, these are things you can do. And finally, I started, when I talked about disclosure, talking about the risks of relying on evidence that's perhaps been created by HR, legal, or employment law consultants. Again, obtaining advice at the outset is imperative, and certainly taking advice from legal professionals. You may say, I would say that I'm a legal professional, but importantly, we see these cases in an employment tribunal. We see these cases where consultants have to send up the file to an employment judge, and these files contain very damaging and incriminating evidence. So again, think about instructing lawyers at the outset. The benefit of legal professional privilege could make all the difference. That's all I want to say on employment tribunals. I do think we have some questions, Kevin, if you want to chip in.
Yeah, thank you, Mark. You've got a couple of questions, and well done for people who sent that in, because I forgot to mention to you at the beginning that there was that facility, but some people will be aware of that anyway. So one of the questions that we've had is about what do you think the impact might be of a looming recession on tribunal trends? I know you talked a little bit about that, but Mark, do you want to address that?
Yeah, I think almost certainly it means increase in tribunal claims. I think there's a user group in Cardiff Tribunal a few weeks ago had suggested there's been a 20% increase in claims. We're going to see that. I think claims are going to become even more valuable. And I know the ONS announced this week that it's the lowest unemployment rate for a number of years.
Yeah, for 4 decades, I think that's right.
But I still think that will perhaps change, and employees will go into a constricted job market, may find it more difficult to secure alternative employment at the same level of salary and benefits as they were earning before. So it just means the value of claims goes up, compensation awards goes up. And Ken, we were chatting a few days ago about insurance.
Yeah, I think it's important to think about what the value of claim is, because while the unemployment rate is really low, then I suppose the factual reality is that if people are walking straight into jobs, then losses are low, in which case the values of cases are low, and that might increase. And I think for a while that's been the case, then I don't think that I would have really been talking to clients about whether you should insure against claims. I mean, that might change. I think it's something that definitely people should keep an eye on in relation to whether that's something that might be worthwhile in the future. I'm not sure that it quite is yet, but depending, I suppose, on your risk profile, and you talked about that, but I think that might be something that would change depending on, as you say, if periods of loss are going to get longer and values go up, then there might be some value if the premiums are right, to look at insuring there. We've had then another question from Sandra. I don't know, and James and Lauren, feel free to turn your cameras on for this one. This is because it's not quite, I don't think, aligned to what we were talking about. But it was, would you advise how an employer can end a 0 hours contract which has been running for some years? Would this be a redundancy situation, or just giving the contractual notice? If notice, is this paid? I think maybe I say what I think, and you feel free to chip in. I think the starting point when you're saying how would you advise on ending a 0 hours contract, I think my starting point would be, well, check it's a 0 hours contract. So I think there's been plenty of tribunals about looking at what the reality is of situations behind the label of the contract, because that's one of the jobs of the tribunal in these sorts of disputes, is to peel the label off the contract and see whether a 0 hours contract really is what it says it is. Because hiding behind the label will be all sorts of things as to whether or not the actual status is really one of employee, worker, or self-employed. And you need to start there, really. You need to start with what the actual status is, and then you need to build on that and see what happens on the ground. And usually with 0 hours contracts, you've got issues of continuity of employment about whether or not someone's built up 2 years, and then that would trigger whether or not you need to be thinking about potentially fair reasons for dismissal, like redundancy or capability or whatever it might be. And then there will be other factors that will determine what notice should be paid. So that might seem like a pretty unsatisfactory answer, Sandra, but hopefully it's a signpost to some of the things not necessarily to focus on, and there are other issues that perhaps you should. And Mark, whether you've got anything that you would want to add to that?
No, I'd agree with that. I think you're right. I think just look at the contract just to ensure it is a 0 hours contract, because the number of contracts I've seen where maybe clients describe them as a 0 hours contract, actually they're not. They're a permanent contract, or the way in which the employee has worked over time has meant that it becomes implied as a
yeah, that's it. The reality is actually something very different to what's written down anyway. Even if you got the actual contract turned out to be right, then if the reality behind it is wrong, then you started off on the wrong foot in considering how you might terminate that relationship. We've run slightly over, but I hope you'll forgive us for that. I think it just maybe remains to say, well, first of all, thank you to the speakers. There are contact details for them if you wanted to follow up with any of those individually. If you don't have a pen or a camera to hand, then we will be emailing you with a copy of the slides and a link to the recording. So if you're ever lonely and just want to see our faces again, then you can do that. And if there are issues that you would like us to talk about in the future, then we're really open to that, because every quarter we're normally racking our brains to think, what are people interested in hearing about? So it'd be a good idea if you tell us, and also tell us if you would like this to return back to what it was, which was, it started out live before the invention of Zoom and so on, as a live event with real people. So we'd like to hear your views about any of those things. And I think that's it then for today. I hope you have a good remainder of the week, and we'll see you all hopefully again soon. Cheers.